in this first term of his, hopefully his only term, we're going to probably have 10 to 15 million people illegally cross the southern border from around the world. I mean, the word has gone out. I was just reading a story about a pipeline of people from, I think it was Mauritania, who have figured out how to get across our southern border. So we have completely abandoned a core principle of sovereignty in this country, a core principle of our immigration laws, which is that we determine who comes into the country. And Joe Biden has completely abandoned that. And I think that's an impeachable offense right there. And I think Republicans politically would be better to impeach him for that than to impeach him for Hunter Biden.
Welcome to another episode of Counterculture, the show that stands at the intersection of reason and faith in the battle against sentimentality and preservation of Western civilization. What are conservatives to do in the age of the left's lawfare? Should conservatives go impeachment for impeachment, political prosecution for political prosecution, inquisition for inquisition? Or, by seeing the difference between the two sides, would conservative constitutionalists be playing right into the hands of those who seek to destroy all the foundations of a free society? To help us with the answer to these questions and more, we're pleased to be joined by William Jacobson. Jacobson is a clinical professor of law and director of the Securities Law Clinic at Cornell Law School. He's the founder of legalinsurrection.com, a must-read blog covering salient legal issues of the day. And he's the president of the Legal Insurrection Foundation, as well as the founder of the Equal Protection Project, all of which we'll discuss. And maybe we'll ask Professor Jacobson how he survives in the Ivy League these days as well, psychologically speaking, of course. After our discussion, please leave a comment and sign up for future episodes by subscribing to or following this channel. Professor Jacobson, thanks so much for joining us on Counterculture.
Thanks for having me on.
You know, before we get to some of these legal issues, and there's much to discuss, including the upcoming term of the Supreme Court, I mean, how is it in the Ivy League for someone like you who's got a very public profile with legalinsurrection.com and the work you're doing at the Equal Protection Project? Yeah, I remember talking to Amy Wax, a professor of law at University of Pennsylvania, a couple years ago, and she basically said at the time, you need to blow up the Ivy League and start over. The Ivy League needs to be completely rethought and restarted from ground up. I wonder where you find yourself in the Ivy League these days.
Almost alone, put it that way, that it is absolutely true that it is a monoculture, certainly at Cornell, and it's probably not as bad as at Cornell as at some other places like UPenn and Columbia and Yale and Harvard, but there is at the faculty and administrative level a near 100% progressive outlook on things. So the handful of conservative professors who are on campus, who've made it through the various screening mechanisms, are subject to various forms of pressure when they speak out. Some get fired, some just get harassed, some are someplace in between. I'm probably in that someplace in between. I haven't been fired, but definitely harassed. So I think it's a very tough situation. I think that higher ed, particularly at the elite level, whether it's Ivy League or just elite colleges and universities, is really broken. I don't think they are capable of reforming internally because over 2 to 3 generations, they have eliminated diversity of viewpoint on campuses. So I think it's a real problem, and I think the pressure for change is going to have to come from the outside.
And yet the problem, of course, is the sort of the institutional rallying around the flag, including from the media. I mean, the U.S. News and World Report just came out with their 2024 best colleges, universities, which of course confer status. And who's number one with a bullet? Princeton. So, you know, the reputations persist long after maybe they're warranted.
Yeah, that's true. I mean, Ivy League schools, top tier schools have really become credential factories. They're not educational institutions for the most part anymore. Certainly, you can get an education there, but most people fight to get into the Ivy League because it's a credential that they think will open doors for them. And to some extent, they're right. Okay, if you want to get hired by the top investment banks, if you want to get hired by the top law firms, coming from a top tier school is a credential which in and of itself will get you the interview that you never would have gotten otherwise. So I think that a lot of the reason that the Ivy League and the elite schools are insulated from a lot of the other pressures that, middle ranked or lower ranked schools get is that people will go there no matter what, because it's a credential they want to have on their child's resume.
I mean, they're certainly testing the boundaries. I mean, my alma mater, Northwestern, did it a few years back with the sex toy class. Princeton, the #1 school in the nation, according to U.S. News and World Report, has a new drag university program that is offered through the school's Gender and Sexuality Resource Center, which includes topics like history of drag, choreography, face painting, photo shoots, and other topics about how to be an effective drag queen. And you do this program on scholarship for all those downtrodden kids who are going to Princeton. But I mean, it's almost to the point of they're openly ridiculing. There's nothing we can do to people of good sense and common decency that will deter us in any form or fashion.
Yeah, and I'm not sure those topics should be banned.
Not banned.
I'm not a banned sort of person, but the point is, are they mandatory? Has it seeped into the programming of freshman orientation? So the problem is not that some college has some wacky course that you can sign up for or not sign up for. It's a worldview that permeates the campus. That's the problem, and it's
indicative. It's indicative of something larger, right?
Yes.
Yeah.
It's the symptom. Yeah. It's not the problem. It's the symptom.
Right. Exactly. By the way, just on Cornell, I thought this was interesting too. I know you covered this a lot during the height of it, and we still have some 80 universities, according to one count, that have vaccine mandates in place for students that would want to learn and reside on campus. But Cornell agreed to pay out $3 million to settle a 2020 class action lawsuit filed by students after Cornell shut down in-person learning, and the students did get the reimbursements they demanded because they weren't getting the education they paid for. I think that this was interesting to settle this. I'm not surprised with deep pockets that Cornell would settle it, but it does set a precedent for students and parents at other schools where that may be useful.
Yeah, I mean, for Cornell, $3 million is a rounding error. Okay,
right, I know.
They throw away $3 million on complete nonsense all the time. It's a multi-billion-dollar operation. To get rid of this, it was well worth the $3 million, I'm sure.
Right. But maybe it's some other schools that, that's material money. And so I say, as I say, the precedent setting. All right, let's get into some legal topics here. I just want to start. I know we've talked a number of times on the radio program I host in Chicago about the Trump trials, but just sort of a summary discussion of it. We don't need to go chapter and verse on all 4 of the indictments. Which to you is the most absurd of the charges, and which to you presents the most legal peril to Trump? And maybe that's the same case. I don't know.
Yeah, and maybe they're all of the above. So I'd say the most absurd one is the first indictment in Manhattan on what is essentially a bookkeeping charge, okay, which was manipulated under a legal theory that even left-wing legal pundits call into question to convert a low-level misdemeanor, falsification of business records, which is the statute of limitations has long since passed, into a felony, which the prosecutor thinks will allow them to avoid the statute of limitations, and the felony being that it was done for another purpose, and the purpose was to violate the federal election laws. But of course, Trump's never been charged with violating the federal election laws. So that is the most absurd of them. It's a low-level bookkeeping charge that nobody ever really gets charged with anyway. It's like jaywalking. But they've turned it into a big indictment and case against him. So that's clearly the most absurd. The one I've always argued since day one posed the greatest, or I should say clearest, legal threat to Trump was the Florida records case, the one where he's charged not only with possessing records he had no legal right to possess that contain national defense information, but also then obstructing justice by causing boxes to be moved around and by causing secure, or at least instructing people to delete security surveillance tapes of the storage area where the boxes were kept. And the reason I've always said that's the most threatening to him or most clear liability is it, unlike the New York one, for example, it doesn't rely on some wacky novel legal theory. It's kind of straightforward, whether they can prove it or not. And I'm not saying he's guilty of it, but if they can prove the facts, it's a pretty straightforward legal theory. So I've always said the Miami or Southern Florida case posed the most direct to him. And then, of course, we have the conspiracy cases in Washington, D.C. in federal court, and the conspiracy case going on in Georgia now.
Right, and then the classified, the problem I suppose the left has, at least with half the country, is, you know, the classified docs case, even if you say you prove beyond reasonable doubt that he violated the letter of the law, then they look at the disparate treatment of Hillary Clinton and Biden from the Department of Justice. And I understand that just because somebody got away with it doesn't mean everybody gets away with it. But in a political context, which is this is all in a political context, people sort of dismiss this out of hand. I wonder if you see from what we know so far, and I'm sure we'll learn more as these trials move forward, is there any surprise coming? Do you see any surprise sort of coming up the river in any of these cases that may reconfigure people's attitudes about Trump? They're sort of baked in right now, but maybe there's a star witness or there's an angle that a prosecutor's taking that we're not seeing that could actually change people's opinion of Trump one way or the other.
Well, I'm not sure anything can change people's opinions of Trump at this point. As you indicated, it's baked in. It's going to be really hard. The question is kind of that middle 5% of the electorate or that middle 10% of the electorate. Those are really the people who might be persuadable. And I think that, for example, in the Southern Florida case, if you had a witness come forward who testifies, and I don't know if this exists, but testifies, you know, he told me to go and delete the surveillance video at the time that these records were under, you know, subpoena, that could be damaging. I mean, I think it's going to need to be testimony by somebody who directly implicates him in wrongdoing. Same in the Georgia case. The Georgia case is that RICO racketeering conspiracy case, and you do have some clear crimes alleged, such as, you know, improper access to computer systems, impersonating a government official. But what they haven't done is tie, at least not in their indictment, directly tied Trump to that. So if you, for example, had somebody, maybe the guy who's now pleaded guilty in that case for the access to computer systems, if you had him come in and testify, well, I spoke to Trump about it and he told me to do it. Right. I mean, that might change attitudes. We don't know if they have that evidence. But as of now, I think if there's a witness who clearly implicates Trump directly in criminal wrongdoing, that I think could sway, you know, public opinion. It's not going to sway his diehard supporters, and it's not going to sway his diehard opponents who hate him anyway. But that middle 10%, it could have an impact.
And the flip side of that is, like in the Georgia case, particularly that case, since it's going to be televised, if you have nothing more than what Fani Willis outlined in her indictment, phone calls and tweets and so forth, and you have you know, people saying, well, I never spoke directly to Trump. This was something that's part of the campaign at the state level or the local level or whatever. If you can't implicate him and then you have sort of the presence of Trump there and the dots just aren't connect, there's sort of these double bank shots where you're supposed to insinuate things, as she did in her indictment, then that could redound to the benefit of Trump. Yeah,
I mean, I think the Georgia case in particular, by asserting a RICO claim, Racketeer Influenced and Corrupt Organizations Act claim, they are seeking to hold him liable for what the supposedly corrupt enterprise, which would be more broadly speaking, the Trump campaign or the Trump effort to overturn the election. They are seeking to hold him responsible for everything that took place as part of that enterprise. So including things he may not have even known about.
Right.
Did he even know about that access to the computers? All of that. So he may be held legally liable if they get through those legal hurdles of proving an enterprise, et cetera, et cetera. But it's not going to sway public opinion one way or the other unless you have him somehow directly involved. The fact that you came up with a legal theory that holds him liable for things he may not have even known were going on, I think it's going to feed into his victim narrative that he is the victim of an unfair prosecution.
Sticking in Georgia and going back to the question I sort of introduced at the outset, what are conservatives to do about the left's lawfare? How are they to conceive this? We sort of have, the argument goes from the left, we have an impeachment for impeachment, eye for an eye going on right now with the House's impeachment inquiry into McCarthy. Initiated by McCarthy into Biden, of course. And I'm not saying that's vengeance, but it's going to be perceived as such by half the country. And maybe some people on the right, I know some people on the right saying, I don't care if you perceive it as vengeance or not. Number one, it's legitimate. Number two, we should be seeking vengeance. We should be seeking to use their precedents against them. And, you know, I wonder if you have any caution you'd like to provide about this idea that we should adopt the lawfare of the left and the examples that are all too well known and pursue exactly those, use exactly those approaches in pursuit of our political enemies. So, for example, there's a Georgia state senator who's now been sort of temporarily thrown out of his caucus, who is moving to have a special session to remove Fani Willis from office. And he was rejected by his own party. He's sort of ostracized from the House Republican caucus in the state of Georgia right now. And so people are rallying to his defense and say, it's exactly what we should be doing. We should be looking for avenues under the law or to advance new legislation, to make new law, to do to them what they've been doing to us. What do you say to that sort of attitude and debate?
Well, you know, emotionally, I'm completely on board with that. I think that until Democrats pay the price of their own misconduct by having it turned against them, they're never going to stop. You know, all these people say, well, if, you know, Republicans need to be held to a higher standard, we can't do the bad things Democrats are doing because it's not right. You know, but there's a part of me that says they're never going to stop unless those bad standards are turned against them. But there's another part of me that says, let's not lose sight of the prize here. The prize here is regaining the presidency. Yes, holding the House. Yes, regaining the Senate. Those are important. But the executive branch, as we've seen under Biden, has such enormous power. They do so much. And even if you can stop 10% of it in the court system, you can't stop 90% of it. You can't stop the Biden administration in the court system from basically refusing to enforce the immigration laws. It's very difficult. So the prize is regaining the White House and the executive branch. And that's how I would view all of these issues is don't worry about, is it right? Is it wrong? Is it good? Should we get even with them? Should we not get even with them? Is it going to help us get back the White House and the executive branch? And I don't, you know, so I'm not sure what the answer to that is, but that always needs to be the goal. That is the prize. The prize is not impeaching Joe Biden in the House. He's never going to be convicted in the Senate. He's never going to be removed in the Senate. Now, maybe it's okay to impeach him just to put a ding on his record, but is that going to help us or hurt us in terms of getting back into the White House? And that, I think, has to be the analysis.
Well, just following up on that, Professor, I mean, because just so I want to get your argument clear, with respect to looking at these decisions through that electoral prism, you're not saying that the ends justify the means. There is a limiting principle here.
Yes, I don't think we should be, for example, impeaching Joe Biden or indicting Democrats without a legitimate basis to do so. I don't think that, you know, if there was no basis to impeach Biden, we should do it just because they did it to Trump. But I think there are at least potentially legitimate bases for impeaching Joe Biden, not just the influence peddling to enrich his family while in office, but also the fact that he has completely refused to support the defense of our southern border in defiance of our immigration laws. In this first term of his, hopefully his only term, we're going to probably have 10 to 15 million people illegally cross the southern border from around the world. I mean, the word has gone out. I was just reading a story about a pipeline of people from, I think it was Mauritania, who have figured out how to get across our southern border. So we have completely abandoned a core principle of sovereignty in this country, a core principle of our immigration laws, which is that we determine who comes into the country. And Joe Biden has completely abandoned that. And I think that's an impeachable offense right there. And I think Republicans politically would be better to impeach him for that than to impeach him for Hunter Biden, maybe both. But, that is a political issue that's going to resonate as opposed to Hunter Biden, which will be viewed as a tit for tat sort of thing.
Well, and talk about a RICO case, you could fold in Garland and Mayorkas to the impeachment if the issue was over failure to enforce immigration law and provide for the nation's security. Absolutely.
And that's, I think, going to be that's an underestimated issue in this electoral cycle.
One other issue, and this may be a bit esoteric before we get to some of the work that you're doing with the Equal Protection Project, which is really interesting. But the Supreme Court has just started its new term, and there's a bunch of cases before the Supreme Court that people are going to be watching in terms of their impact. There's a gun case, there's an abortion case, there's a social media censorship case. But there's two administrative law cases. One has to do with the Consumer Financial Protection Bureau and whether or not basically legislative authority was usurped to set up that agency in the first place, Elizabeth Warren's favorite agency. And then the other one is administrative law case that deals essentially with the Chevron doctrine, that where the law is silent, federal agencies should have sort of wide berth to fill in the blanks. And, as we talk about, against the backdrop of this recently avoided government shutdown, in quotation marks, but also passing $33 trillion in debt and the profligacy during the COVID years on spending, the administrative state is maybe more in focus than it ever has been. And I wonder what kind of importance you place on those two cases, the Consumer Financial Protection Bureau and the Chevron doctrine. Are they both important? Is one more important? Are these going to be sort of key cases if we're ever going to reduce the size and scope of Leviathan, the decisions in those cases?
Well, I think they are important, but I wouldn't overstate the impact that these cases will have. They're things that get lawyers all excited, and occasionally it gets the media that focuses on law excited, but they're really legal sort of things. The administrative state is going to continue to grow. It's going to continue to have enormous power. This may, peel it back a little bit around the fringes. It will deal with what authority different entities have. I think the Consumer Protection Bureau case is perhaps more directly implicated because what Elizabeth Warren and the Democrats did is they created an entire massive agency completely outside or close to completely outside of congressional oversight, completely outside the congressional budgeting process. They've created, a entity which you may like the job it's doing or you may not like the job it's doing, but why should it be, a perpetual, permanent, independent agency that no one has control over from the political process? And so I think that one might have a more direct implication, but nothing here is going to slow down the growth of the administrative state, the permanent bureaucracy that seems to rule no matter who is the president. And that's why I get back to the issue that if you want to pare down the bureaucracy, you have to get control of the executive branch. And, I know Ron DeSantis has proposals, I assume Trump does, and maybe other candidates to try to pare back the administrative state, because that's who really runs this country, not the politicians. But these cases are important legally, but they're not going to change the world.
They could change pace, but not ultimately direction. That's right. Basically it.
Yeah.
I wanted to explore a lot of people viewing this, I'm sure, are familiar with legal insurrection. But the new project, the relatively new project, the Equal Protection Project that you launched, give us the basis for that and the mission of the Equal Protection Project.
Sure. Well, so Legal Insurrection Foundation is our operating entity. It's a tax-exempt 501c3. It has three projects. One is the traditional legal insurrection blog, legalinsurrection.com, which is how most people know us and most people assume is what we are. But we also have two other projects. We launched criticalrace.org in February 2021, which documents over 700 schools how critical race theory in its various forms has taken over higher education. So we have over 500 colleges and universities in our database. We have all 155 medical schools, and we have other databases. In February of this year, we launched Equal Protection Project, which is equalprotect.org, because through the CRT website, we were getting a lot of complaints from people, a lot of tips from people that they're seeing all sorts of bad conduct going on in higher ed, open discrimination in the name of diversity, equity, and inclusion. And until Equal Protection Project, we couldn't do anything about it. We could just report on it and put it in our database. So we created equalprotect.org in February of this year to bring legal actions against colleges, universities, and public schools and anybody else, but mostly we're focused on the public sector in education now, where there are discriminatory grant programs, where there are grant programs open only typically to non-whites, where there are scholarships typically only open to non-whites. And we've challenged many of those. We've challenged over a dozen of them. And that is our attempt to address the discrimination done in the name of DEI. We started that before the Supreme Court rendered its decision in the Harvard case. And the Harvard case reinforced our principle that everybody is entitled to equal protection of the laws, that everybody is entitled to be treated equally without regard to race, and that the goal of diversity is not a legal excuse to discriminate on the basis of race. And so Equal Protection Project really gave us that platform and that mechanism to take action on these issues as opposed to just reporting on them.
Yeah, I think people vastly underestimate how much this sort of separate but equal Plessy v. Ferguson standard that was overturned in Brown v. Board of Education, I think people underestimate how much it has reasserted itself, how much pro-separation by race is out there. I spoke with a woman, a relatively high-profile case out of Atlanta. Now, this is at the grammar school level, but a black woman who had to sue her school district, an educator by background, as was her husband, sue her school district because they were putting her daughter in a class with only black students and a black teacher, and the white students were in an only white class with a white teacher in the same grammar school, like second grade. And you would think that would be like a hue and cry if this was being done at like a conservative Christian school. I mean, the country would be on fire over it. Barely anybody knows about this case, but it's the same sort of dynamic. And this is a black mom, as I said, a black family, suing a school district with a black principal and so on and so forth. But there's the real promotion, there's a real belief in certain quarters in education all the way up to the university, and probably from the university back down to K through 12, that separate but equal is something that we should not only reconsider, but implement.
It's actually shocking, some of the cases that we've seen. And what really was the impetus to launching Equal Protection Project was that one of the tips we got through criticalrace.org was about a program in the Providence, Rhode Island school system. Now, we're a virtual entity, but we're based in Rhode Island. And someone had called to our attention that the Providence School District had a new teacher hiring program. They called it the Teacher of Color Loan Forgiveness Program. Kind of the title gives away the punchline, but the punchline was, if you're a new teacher into the Providence school system, biggest school system in the state, and you have student loans, they arranged for a charitable foundation, the Rhode Island Foundation, the biggest charity in Rhode Island, $1.5 billion charity, to pay off up to $25,000 of your student loans, but only if you're non-white. And they do this out in the open. They do this without any shame. It's part of their DEI programming in Providence. So we filed a complaint about that. That's now with the EEOC, which is investigating. We're hoping they'll take action. But we got a lot of publicity about that. Providence doesn't care. The thing people need to understand is that things that we would think would shame people into stopping what they're doing, like, you're discriminating on the basis of race, you're resegregating the school system. They don't care. The racial ideology that has taken over academia from the medical schools down to kindergarten is so invasive and so permeates the system that they don't even realize the unethical and illegal absurdity of what they're doing. And they're not going to stop just because the Supreme Court issued a ruling. They're finding all sorts of other ways to hide this stuff. But we're fighting it wherever we can. We're a small organization. If we had 10 more people, we could keep them all busy, but we don't. People would be shocked to find out what is going on.
Well, and the funny thing is, and it's not ha-ha funny, sad funny, is that this was entirely predictable. Once you go down this road of conferring benefits or imposing responsibilities based on race, you're ultimately going to get to that place. You're ultimately going to get to that place of segregation, because there are the people that should be receiving benefits, and then there are the people that shouldn't and should just be having to abide obligations. And so it's sort of the logical conclusion of this poisonous identitarian ideology.
Yeah. Now, sometimes publicity about these things and public shaming of what these administrators are doing is enough. So, for example, we brought a claim against both the University of Minnesota and Missouri State regarding programs they had that excluded whites from them. The one in Missouri State excluded only white males from a business boot camp that they were running at the school. Minnesota had something similar, and they did stop when they got a lot of bad publicity. But other places like Providence and many other schools, they don't stop until somebody gets a court injunction telling them to stop. They won't stop. And that's hard to do because, as you're probably aware, it's hard to get plaintiffs who are willing to put their name on a lawsuit. And you need somebody directly implicated to, go to court. And we've had many people, students, teachers, who say, I see these practices going on. I'd love to sue, but I can't because there'll be retaliation. I'll never work again. I'll never get a job at another school district if I sue this current school district. And I can't tell them that they're wrong. Contrast that with the left. When the left brings lawsuits, they are falling all over themselves for people to put their name on it because they know there won't be any retribution against them. In fact, they'll be treated as heroes. And so it's really this disparity, but we're doing what we can to try to put an end to these bad practices. And there are other groups as well, but we're really the only one specifically focused on DEI discrimination. It's really unbelievable what's going on. And now that the Supreme Court has ruled the way they have, they're going to start to take it underground. They'll no longer put it on their websites. So we're going to have to rely more on tips than we ever have before.
Well, the other thing that was interesting about this case in Atlanta I was mentioning is, I asked Ms. Posey about, well, what are the other parents' reaction? You're in an affluent school district, it's white, it's black, it's all professionals. So nobody else heard about the segregated second grade classrooms and said, well, that doesn't seem right. That seems a little off. We don't want to do that. And she's like, well, some parents did, but there are a lot of parents, you'd be surprised, who were upset at me because I'm bringing shame on the school. And we moved to this neighborhood. We're in this neighborhood because of the status that's conferred by sending our kids to this school so they can get status by the next school they go to and so forth. So, also just sort of the sickness of the, not necessarily racist, but the amoral status seeker. And you have to confront that aspect of our culture too.
Yeah, virtue signaling and things like that are completely out of control. There's the white savior complex that people think that by treating blacks separately or treating non-whites separately, they're somehow helping them. And, a lot of black parents are pushing back against that. In this Providence case that I was talking about with the school district, a group of local black education activists came out and said they agree with us, that they do think there should be a more diverse teaching force, but this sort of discrimination doesn't help. And I think, that's what people fail to see, that by reinforcing essentially negative stereotypes that, either black people or non-white people are incapable of succeeding unless they're given extra special benefits. That is actually very demeaning to those communities. That is sending a message to their children that they are doomed to fail, that they are somehow starting at a disadvantage. And that's simply not true. Whether it was true 60 or 70 years ago, we can talk about, but it's not true in 2023. And people need to come into the modern era. It's 2023, not 1953.
Rewind a little bit. What was your original inspiration to start Legal Insurrection and the blog?
Well, it's something of a funny story that it was never planned. So I joined Cornell in late 2007. I didn't start the website for almost a year. I was completely non-political. I never would have been hired had I been political. And in 2008, I began to get more and more frustrated with the media bias in favor of Obama and against McCain. And in late August, I was having dinner with a former client of mine because I had previously been in private practice, someone I'd made a lot of money for. And he asked me who I am voting for. And I said, I'm voting for John McCain and Sarah Palin. And he must have assumed I was liberal like he is and everybody else was in Rhode Island. And we got into a long argument. And at the end of it, he says, I've never heard anybody state your side of things as well as you do. You should start a blog. I had no idea what a blog was. I didn't follow politics really that carefully. And so I said, well, maybe I should do this. And so I found Google Blogger, which was free and really simple. I don't know if it still exists, but it existed back in 2008. And I said, okay, I'm going to start to write about these things. And I needed a name for the website. And I did word association. And what was coming to mind was the word insurrection back in 2008.
Yeah, wow, right.
And, so frustrated. And then I looked up the word insurrection, and by definition, it's illegal. I thought to myself, well, I just started a year ago, a new job as a law professor. Maybe an illegal name isn't right. So I said, let me call it legal insurrection, which is actually a contradiction in terms. It's an oxymoron. And that was the branding, very sophisticated branding. Cost me nothing. And so I started to write in October 12th. We're coming up on our 15th anniversary. October 12th is the 15th anniversary of the launch of Legal Insurrection blog. And the first post was about Obama and how he's much more radical than he's letting on, that he has carefully curated his own biography. The only things we really knew about him at that time were things he disclosed, but his ideology and other things were very hidden. And he used the issue of race to avoid scrutiny of his radical underpinnings. And things took off from there. And here we are 15 years later with the whole operation.
Well, that's why it succeeded. You were ahead of the learning curve, at least with respect to most of the nation, not from Chicago. He is Professor William Jacobson, Cornell Law, legalinsurrection.com, Legal Insurrection Foundation, and the new project, the Equal Protection Project. Professor Jacobson, thanks so much for joining us. Really appreciate your time.
Great. Thanks for having me on.
Thank you. Please like this video and subscribe to this channel if you haven't already. And please leave a comment in the comment section. We'd love to hear your thoughts.